is just one small sample of all the different ways to get evidence admitted or excluded and all the different cases involving it. I've been doing this shit for 19 years, okay? I've won close to 90% of my cases. I just had a jury decision come back in my favor in 34 minutes flat. It's from knowing the cases, knowing the code, and knowing how to exclude evidence or get evidence admitted. So if you do not know that and think it's just a matter of just yelling at the judge to get your way, you're going to get your ass royally kicked. So here was an ex parte harassment hearing, which is before a judge. It's never before a jury. Now, first thing, Lane, you're present, and she's got all these exhibits. So rule number one, exclude the evidence. If it's a copy of a social media post that involves your channel, then it would come in as a party admission, and there's different ways to authenticate it that way. And every exhibit is admitted into evidence. What about yours? Well, you came in with Exhibit A USB drive, which means it was identified, but it was not admitted into evidence. So the judge looking at this says, okay, I got 14 exhibits and I'm now weighing the case and I have no evidence from you other than what you said. You're off to a terrible start. They find that the plaintiff is credible and you are not credible, that you've caused third parties to communicate with the plaintiff by explicitly and encouraging contact. And if you call people because you don't like what they said and you're trying to antagonize them, you move from First Amendment to harassment. And none of that is protected in the First Amendment. In fact, it can be a crime, federal cyber stalking statute. Look what happened to Craig Henry. He asked his followers to pile on to some people he did not like, and that wound up getting him more time and sending him to prison. The court repeatedly ordered the defendant to leave the proceeding due to not following the rules, and he failed to do so, violating a court order. The defendant left during the proceeding using insulting language towards the court and threw his exhibit at the court staff. All right, so now when the judge is deciding whether or not you are a candidate for a restraining order and you throw stuff at the court staff, use insulting language, if you act like that, you're not going to win your case. And the judge is going to think, like most judges think, you would typically be on your best behavior. And so if this is your best behavior, what are you like outside in the courtroom? And then you accepted service of the protective order, probably the bailiff handed it to you right there after it was signed, and now you're stuck with it because now you got service. All right, so then there was another hearing. Defendant was not present. Victim is present. And so Lane has an attorney for him, which is good. And it says the defendant was admonished regarding his tardiness. They put this on the record to build a case against you. Disclosure not to be stated in this matter, notwithstanding the filing of a SLAPP motion. Now there, I like that. For you guys, you know how I'm about anti-SLAPP motions. Whether or not this is legitimate petitioning activity is a defense to harassment charges. Disclosure shall not be stated notwithstanding the filing of an anti-SLAPP. In California, the filing of an anti-SLAPP motion would stop all discovery absent good cause. Order defendant shall not email, telephone, or otherwise contact a judge or judicial staff. So that sounds like, are people from his followers or his friends hitting the court with all kinds of stuff to disturb them? Defendant is admonished he must be present for said hearings and advise the constable should he fail to appear. And this motion to exceed page limit to the anti-SLAPP is granted. It's odd that you would do that in the first instance. The memorandums always have limits. California is 15 pages without permission. Potential new charges and in an unindicted manner. So they're just like, look, rather than make a big to-do about this, we're just going to continue to add charges. Now here, I find this to be a very big mistake. Lane is now going to represent himself. Defendant shall be held in custody with a bond set at $500 cash secured. Now, court admonishes the defendant regarding courtroom decorum. Yikes. See, that can lead to separate charges. It can be criminal contempt charges. So you don't want to do any of these things. I pulled the different sections here. Make this a little bit larger. And this is a lot of stuff. And then there was another case opened where there were 6 additional charges. And again, stalking, intimidation, threats, harassment, electronic communications, interference in judicial proceeding, aggravated harassment, first-degree misdemeanor, count 3, interfering with judicial proceedings, engages in disorderly, disrespectful, and insolent behavior during the session of a court, which directly tends to. Those are very easy to get convicted on. The judge can convict you himself on that. Counts 4 and 5 were M1, 6 months, use of an electronic communication to terrify, intimidate, threaten, or harass. So notice that it's or harass, so it can be harassment. unlawful use of electronic communication. I bolded the sections that he's being charged with. A3, disturbing by repeated anonymous, unwanted, unsolicited electronic communications, the peace, quiet, or right of privacy of the person at the place where the communications were received. Here are the defense for the anti-SLAPP. Constitutionally protected speech activity to any activity authorized by law is a defense. You've got to be able to argue that. And here, part of the charge is always is at least 2 or more instances. It has a continuity of purpose, and it doesn't serve any legitimate purpose. Social media posts count for electronic communications naturally, and it's a willful course of conduct, which means you have to intend it. It can't be accidental, and it has to be targeted, okay? And then seriously alarming. So in here, it's not just alarming, seriously alarming. So they're really trying to narrow the range of behavior. Seriously disrupted, seriously. So they're being serious about that. We have another charge that he is facing under A1, contacts or causes a communication by verbal, electronic, telephonic, or written means. And again, it's knowingly, repeatedly commits an act or acts of harass. Aggravated harassment. Now, this is where the aggravated charge comes in. A person commits aggravated harassment. In other words, they have not learned their lesson. And at the time that they're being charged with the offense, a court has issued any of the following orders in favor of the victim of the harassment, and the order was served on the person. The order was valid at the time of the offense. So remember, I showed you the minute order where he accepted service. He's been served. And order of protection, injunction against harassment, any other criminal-related injunction. So basically, if you've been nailed for a protection order of some kind, and then you do it again, and you were served with the order, so therefore you're charged with knowledge of it, now they can intensify the charge. Stalking, it was a 3rd-degree felony in count 6, and then 5th-degree count 14 in the other case, and he was charged with A1 and A2. So I started to look at the punishments here for the different ranges of felonies. There was 1 6th-degree felony, 1 3rd-degree felony, and 8 5th-degree felonies. And looking at the minimum term for all of them, it would be 6.33 years just for the felonies alone, and a maximum term of 24.5 years. If he were to get convicted and everything was strung together consecutively, that usually does not happen. It could very well be that some of these charges are going to get dropped because they're so repetitive and so cumulative, and then it just becomes piling on. Then I took a look at what is an aggravating factor under Arizona Revised Statute 131710D, and they have a list of items here. And a couple of them, like the defendant committed the offense as consideration for the receipt or expectation of receipt of any pecuniary value. So one thing the prosecutor might argue is that the YouTube channel was the basis for that and the monetization, and there was the pecuniary value. The victim or the victim's family suffered physical, emotional, or financial harm. Kind of unusual that this would be considered aggravated, because that would be the whole point of harassment anyway, was to inflict that kind of thing. So the bottom line is that he is not acting very well in court, according to these minute orders, which can add to their own separate charges and separate offenses. That kind of gets into due process issues. Are you really creating too many charges over the same type of conduct? I would strongly encourage you, Lane, to get yourself a really good defense lawyer, because you're going to need to knock these charges down. You're going to need to be able to prove that the statements made against you are not admissible, and find evidentiary ways to protect yourself. And that is just really not going to happen if you're representing yourself. For example, I had a client who was hit with a switchblade knife charge. And when I brought the case law to the DA, they were like, sounds good to me. Case dismissed. Anyway, hope you liked the video. Like and subscribe. Thanks, guys.